Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlight Series. Today we focus our attention on CG 3.9, in which we explain the structure, functions, and processes of the judicial branch of government. In Part 1, we focus on judicial branch processes and the structure, functions, and powers of courts at the state and federal levels. We focus our attention on benchmark clarifications 1 and 2. In benchmark clarification 1, students examine the processes of the judicial branch, while in benchmark clarification 2, students distinguish between the structure, functions, and powers of the courts at the state and federal levels. What are the processes of the judicial branch of government, and what are the differences among the structures, functions, and powers of the courts at the state and federal levels? There are various processes that are employed by the judicial branch. One of these processes is called original jurisdiction. Original means first. If a court has original jurisdiction, it has the power to hear a case first. So, for example, the United States Constitution provides a specific list of situations where the United States Supreme Court, the highest court in the land, is also the court of original jurisdiction. This means that the Supreme Court is going to be the first court to hear this case because this case involves a dispute where the U.S. Constitution has determined that the Supreme Court should be the first court to hear a case. So one example is cases involving disagreements between two states. And we imagine that that makes good sense. After all, who would be available to objectively resolve a dispute between two states? Certainly it wouldn't be a court within one of those two states. So here the U.S. Supreme Court is the original jurisdiction court. Appellate jurisdiction means that a court has the power to review cases that have already been decided by lower courts. Most cases come to the U.S. Supreme Court as appeals cases. This means that the person who lost a case believes that the law was not interpreted properly, that there was a problem with the process that the person might have gone through, such as a criminal procedure, and therefore the person might believe who lost the case that they were improperly prosecuted, so they might appeal the case. Higher courts have the power to review cases that have already been decided by lower courts, and that is what we call appellate jurisdiction. Now, judicial review is a concept that allows the federal or state Supreme Court to decide whether a law is consistent with the federal or state constitution, or the Supreme Court can decide whether a law is constitutional. This concept of judicial review was determined to be constitutional, part of the Constitution, based on the powers that the court has, but the actual phrase judicial review does not appear anywhere in the U.S. Constitution. Unlike the other two terms that we've reviewed so far, where original jurisdiction and appellate jurisdiction do appear in Article 3 of the U.S. Constitution. So in essence, the U.S. Supreme Court decided, based on its interpretation of the Constitution, that they were entitled to decide whether a law is or is not consistent with the federal or state constitution, or whether a law is constitutional. Courts may also issue court orders. A court order is a document that requires that someone do or not do something. So the court is requiring that someone take a particular type of action. Now, the next phrase is a Latin phrase, and it is often pronounced as writ of certiorari, although there is some disagreement on whether or not the phrase instead should be writ of certiorari or writ of certiorari. However, what is the process of this very difficult to pronounce phrase? A writ of certiorari is when a high court decides to accept a case on appeal. This means that when a court is approached about appealing a case, a high court has the choice whether or not to accept the case on appeal. They may review the facts of the case, they may review the reasoning that was part of the decision, they may review the processes, and they may come to believe that what the person who is making the appeal is alleging does not meet the standard of being eligible for review, or they may decide that the argument that the person's making that they are entitled to an appeal is not a good argument, and thus their claims are not taken seriously such that that appeal would be heard. So this means that a writ of certiorari is the evidence that the court granting it had the choice whether or not to grant certiorari. And then finally, a summary judgment. A summary judgment is an issue that is decided based on evidence given to the court that keeps the case from going to trial. So this means that there might be a situation where the court has enough evidence that they can go ahead and decide, and they don't need to actually hold a trial. Here we have a quote from John Marshall. John Marshall was the Chief Justice of the United States Supreme Court at the time. And as Chief Justice, he oversaw the decision in Marbury versus Madison. Marbury versus Madison was a case that was decided in 1803, and it was from that case that the U.S. Supreme Court decided that the Constitution included the principle or concept of judicial review, even though the Constitution itself does not include or specify that power. And what John Marshall said in the court opinion in Marbury versus Madison was that it is emphatically the province and duty of the judicial department to say what the law is. So what John Marshall was saying is that it is our job. We are the judicial department. We decide what the law is. Now, if we think about this for a second, we can see where what John Marshall is saying makes good sense and makes not so good sense. Let's focus on the good sense first. So the good sense would suggest that here somebody who is an appointed official who is in their job for life, so they don't have to worry about where the political winds are blowing, that they can look just at the law and not worry about losing their job, not worry about other concerns, and they can then go ahead and decide what the law is. And who did make the law? Those who made the law were those who were subject to politics, elected legislators and elected executive branch rulers, presidents, governors, etc. So if the head of the executive branch is elected and the legislators are elected, that means that they are subject to political will, and they may also decide to pass laws that they believe are good for them politically, but they may not be consistent with the Constitution. But let's look at this through a different lens. And that different lens is that members of the U.S. Supreme Court are not elected. They are insulated from the public. They are insulated from the legislature and the executive branch. And so some people might say, should an entity like the U.S. Supreme Court have so much power if it is not subjected to oversight and scrutiny by the public or by the other branches of government. So we should look at this quote in different ways. Now we're going to compare the structure and functions of the federal, state, and local courts, focusing on Florida. So there's a federal Supreme Court, there are circuit courts of appeals, and there are district courts. Florida also has a Supreme Court. There are district courts of appeals, and below those we find circuit courts. And then finally, at the local level, there are county courts and municipal courts. Municipal is another term that we often use to represent local government. Here, because we're not talking about county courts, we're talking about lower level than county, so cities, towns, and villages. Those are our municipal courts. Thank you for joining me for Middle School Civics Highlights. Do you still have questions? Please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.